Labor law mediates the relationship between workers, employers, trade unions and the government. Collective labor law relates to the tripartite relationship between employee, employer and union. Individual labor law concerns employees' rights at work and through the contract for work. Employment standards are social norms for the minimum socially acceptable conditions under which employees or contractors are allowed to work. Government agencies enforce labor law. History. Labor law arose in parallel with the Industrial Revolution as the relationship between worker and employer changed from small-scale production studios to large-scale factories. Workers sought better conditions and the right to join a labor union, while employers sought a more predictable, flexible and less costly workforce. The state of labor law at any one time is therefore both the product of, and a component of struggles between various social forces. As England was the first country to industrialize, it was also the first to face the often appalling consequences of industrial revolution in a less regulated economic framework. Over the course of the late 18th and early to mid-19th century, the foundation for modern labor law was slowly laid, as some of the more egregious aspects of working conditions were steadily ameliorated through legislation. This was largely achieved through the concerted pressure from social reformers, notably Anthony Ashley Cooper, 7th Earl of Shaftesbury, and others. Child labor. A serious outbreak of fever in 1784 in cotton mills near Manchester drew widespread public opinion against the use of children in dangerous conditions. A local inquiry presided over by Dr. Thomas Percival was instituted by the Justices of the Peace for Lancashire, and the resulting report recommended the limitation of children's working hours. In 1802, the first major piece of labor legislation was passed minus the Health and Morals of Apprentices Act. This was the first, albeit modest, step towards the protection of labor. The act limited working hours to 12 a day and abolished night work. It required the provision of a basic level of education for all apprentices, as well as adequate sleeping accommodation and clothing. The rapid industrialization of manufacturing at the turn of the 19th century led to a rapid increase in child employment, and public opinion was steadily made aware of the terrible conditions these children were forced to endure. The Factory Act of 1819 was the outcome of the efforts of the industrialist Robert Owen and prohibited child labor under 9 years of age and limited the working day to 12. A great milestone in labor law was reached with the Factory Act of 1833, which limited the employment of children under 18 years of age, prohibited all-night work and, crucially, provided for inspectors to enforce the law. Pivotal in the campaigning for and the securing of this legislation were Michael Sadler and the Earl of Shaftesbury. This act was an important step forward, in that it mandated skilled inspection of workplaces and a rigorous enforcement of the law by an independent governmental body. A lengthy campaign to limit the working day to 10 hours was led by Shaftesbury, and included support from the Anglican Church. Many committees were formed in support of the cause and some previously established groups lent their support as well. The campaign finally led to the passage of the Factory Act of 1847, which restricted the working hours of women and children in British factories to effectively 10 hours per day. Working conditions. These early efforts were principally aimed at limiting child labor. From the mid-19th century, attention was first paid to the plight of working conditions for the workforce in general. In 1850, systematic reporting of fatal accidents was made compulsory, and basic safeguards for health, life and limb in the mines were put in place from 1855. Further regulations, relating to ventilation, fencing of disused shafts, signaling standards, and proper gauges and valves for steam boilers and related machinery were also set down. A series of further acts, in 1860 and 1872, extended the legal provisions and strengthened safety provisions. Steady development of the coal industry, increasing association among miners, and increased scientific knowledge paved the way for the Coal Mines Act of 1872, which extended the legislation to similar industries. The same act included the first comprehensive code of regulation to govern legal safeguards for health, life and limb. The presence of a more certified and competent management and increased levels of inspection were also provided for. By the end of the century, a comprehensive set of regulations was in place in England that affected all industries. A similar system was implemented in other industrializing countries in the latter part of the 19th century and the early 20th century. Individual labor law. Employment terms. The basic feature of labor law in almost every country is that the rights and obligations of the worker and the employer are mediated through a contract of employment between the two. This has been the case since the collapse of feudalism. Many contract terms and conditions are covered by legislation or common law. In the U.S., for example, the majority of state laws allow for employment to be at will, meaning the employer can terminate an employee from a position for any reason, so long as the reason is not explicitly prohibited, and, conversely, an employee may quit at any time, for any reason, and is not required to give notice. One example of employment terms in many countries is the duty to provide written particulars of employment with the essentiale negotii to an employee. This aims to allow the employee to know concretely what to expect and what is expected. It covers items including compensation, holiday and illness rights, notice in the event of dismissal and job description. The contract is subject to various legal provisions. An employer may not legally offer a contract that pays the worker less than a minimum wage. An employee may not agree to a contract that allows an employer to dismiss them for illegal reasons. Minimum wage. Many jurisdictions define the minimum amount that a worker can be paid per hour. Australia, Belgium, Brazil, Canada, China, France, Greece, Hungary, India, Ireland, Japan, South Korea, Luxembourg, the Netherlands, New Zealand, Paraguay, Portugal, Poland, Romania, Spain, Taiwan, the United Kingdom, the United States, Vietnam, Germany and others have laws of this kind. The minimum wage is set usually higher than the lowest wages determined by the forces of supply and demand in a free market and therefore acts as a price floor. Each country sets its own minimum wage laws and regulations, and while a majority of industrialized countries has a minimum wage, many developing countries do not. Minimum wages are regulated and stipulated in some countries that lack explicit laws. In Sweden, minimum wages are negotiated between the labor market parties through collective agreements that also cover non-union workers and non-organized employers. National minimum wage laws were first introduced in the United States in 1938, Brazil in 1940, India in 1948, France in 1950 and in the United Kingdom in 1998. In the European Union, 18 out of 28 member states have national minimum wages as of 2011. Living wage. The living wage is higher than the minimum wage and is designed that a full-time worker would be able to support themselves and a small family at that wage. Hours. The maximum number of hours worked per day or other time interval are set by law in many countries. Such laws also control whether workers who work longer hours must be paid additional compensation. Before the Industrial Revolution, the workday varied between 11 and 14 hours. With the growth of industrialism and the introduction of machinery, longer hours became far more common, reaching as high as 16 hours per day. The 8-hour movement led to the first law on the length of a working day, passed in 1833 in England. It limited minors to 12 hours and children to 8 hours. The 10-hour day was established in 1848, and shorter hours with the same pay were gradually accepted thereafter. The 1802 Factory Act was the first labour law in the UK. Germany was the next European country to pass labour laws. Chancellor Otto von Bismarck's main goal was to undermine the Social Democratic Party of Germany. In 1878, Bismarck instituted a variety of anti-socialist measures, but despite this, socialists continued gaining seats in the Reichstag. To appease the working class, he enacted a variety of paternalistic social reforms, which became the first type of social security. In 1883, the Health Insurance Act was passed, which entitled workers to health insurance. The worker paid 2/3 and the employer 1/3 of the premiums. Accident insurance was provided in 1884, while old age pensions and disability insurance followed in 1889. Other laws restricted the employment of women and children. These efforts, however, were not entirely successful. The working class largely remained unreconciled with Bismarck's conservative government. In France, the first labor law was voted in 1841. It limited underage minors' hours. In the Third Republic, labor law was first effectively enforced, in particular after Waldeck-Rousseau's 1884 law legalizing trade unions. With the Matignon Accords, the Popular Front enacted the laws mandating 12 days each year of paid vacations for workers and the law limiting the standard work week to 40 hours. Health and safety. Other labor laws involve safety concerning workers. The earliest English factory law was passed in 1802 and dealt with the safety and health of child textile workers. Discrimination. Such laws prohibited discrimination against employees as morally unacceptable and illegal, in particular racial discrimination or gender discrimination. Dismissal Convention No. 158 of the International Labour Organization states that an employee can't be fired without any legitimate motive, and, before offering him the possibility to defend himself. Thus, on April 28, 2006, after the unofficial repeal of the French First Employment Contract, the long-due Conseil des Prud'hommes judged the new employment contract contrary to international law and therefore illegitimate, and without any juridical value. The court considered that the 2-year period of fire at will was unreasonable and contrary to convention. Child labor was not seen as a problem throughout most of history, only disputed with the beginning of universal schooling and the concepts of laborers and children's rights. Use of child labor was commonplace, often in factories. In England and Scotland in 1788, about 2/3 of persons working in water-powered textile factories were children. Children workers' guides for tourists, sometimes combined with bringing in business for shops and restaurants. Other children do jobs such as assembling boxes or polishing shoes. However, rather than in factories and sweatshops, most child labor in the 21st century occurs in the informal sector, selling on the street, at work in agriculture or hidden away in houses, far from the reach of official inspectors and from media scrutiny. Collective labor law. Collective labor law concerns the relationship between employer, employee and trade unions. Trade unions are organizations which generally aim to promote the interests of their members. Trade unions are organized groups of workers who engage in collective bargaining with employers. Some countries require unions or employers to follow particular procedures in pursuit of their goals. For example, some countries require that unions poll the membership to approve a strike or to approve using members' dues for political projects. Laws may govern the circumstances and procedures under which unions are formed. They may guarantee the right to join a union, or remain silent in this respect. Some legal codes allow unions to obligate their members, such as the requirement to comply with a majority decision in a strike vote. Some restrict this, such as right to work legislation in parts of the United States. Workplace participation. A legally binding right for workers as a group to participate in workplace management is acknowledged in some form in most developed countries. In a majority of EU member states, the workforce has a right to elect directors on the board of large corporations. This is usually called co-determination, and currently most countries allow for the election of 1/3 of the board. though the workforce can have the right to elect anywhere from a single director to just under a half in Germany. However, German company law uses a split board system, in which a supervisory board appoints an executive board. Under the Mitbestimmungsgesetz 1976, shareholders and employees elect the supervisory board in equal numbers. But the head of the supervisory board with a casting vote is a shareholder representative. The first statutes to introduce board-level co-determination were in Britain. However, most of these measures, except in universities, were removed in 1948 and 1979. The oldest surviving statute is found in the United States, in the Massachusetts Laws on Manufacturing Corporations, introduced in 1919. However, this was always voluntary. In the United Kingdom, similar proposals were drawn up, and a command paper produced named the Bullock Report was released in 1977 by the James Callaghan Labour Party government. Unions would have directly elected half of the board. An independent element would also be added. However, the proposal was not enacted. The European Commission offered proposals for worker participation in the Fifth Company Law Directive, which was also not implemented. In Sweden, participation is regulated through the law on board representation. The law covers all private companies with 25 or more employees. In these companies, workers have a right to appoint 2 board members and 2 substitutes. If the company has more than 1,000 employees, this rises to 3 members and 3 substitutes. It is common practice to allocate them among the major union coalitions. Information and consultation workplace statutes in many countries require that employers consult their workers on various issues. Collective bargaining, collective action, strike action is the worker tactic most associated with industrial disputes. In most countries, strikes are legal under a circumscribed set of conditions. Among them may be that the strike is decided on by a prescribed democratic process. Sympathy strikes, against a company by which workers are not directly employed, may be prohibited. General strikes may be forbidden, for example, among public safety workers, to maintain public order. A boycott is a refusal to buy, sell, or otherwise trade with an individual or business. Other tactics include go slow, sabotage, work the rule, sit-in or en masse not reporting to work. Some labor law explicitly bans such activity, none explicitly allows it. Picketing is often used by workers during strikes. They may congregate near the business they are striking against to make their presence felt, increase worker participation and dissuade strike breakers from entering the workplace. In many countries, this activity is restricted by law, by more general law restricting demonstrations, or by injunctions on particular pickets. For example, labor law may restrict secondary picketing, or flying pickets. Laws may prohibit obstructing others from conducting lawful business, outlaw obstructive pickets, allow court orders to restrict picketing locations, or behaving in particular ways.